Hello, and welcome to the first episode of Litigation Corner, a series where we discuss important issues affecting our community and shine light on successes achieved in the justice system. My name is John Martino, and I am the Director of Litigation for Community Legal Services, a legal aid program that covers 12 counties coast to coast in the middle of Florida. Welcome to Litigation Corner. Community Legal Services, CLS for short, is a nonprofit law firm. One of our goals of CLS is to eliminate something we call the justice gap. The justice gap is the difference between the legal needs of low-income people and the resources available to help them. Legal aid firms across the country, like CLS, work to minimize and someday hope to close the justice gap. For us, that would mean a society where everyone is equipped to recognize when they have a legal issue and that they can navigate the systems needed to help resolve it. How do we get there? Our mission is enhancing the lives of those we serve through accessible legal support, assistance, and education. Today, we're going to focus on education for those who do not have an attorney. For several years, I worked as a family law attorney at Community Legal Services. Over time, I came to realize that as much as we would like to help everybody who calls, there are only so many hours in a day, and we only have so many attorneys. That means that many people will face legal challenges without the ability to hire a lawyer. But here's the good news. You can represent yourself in court, and you do have rights. I've worked with countless individuals who have had to navigate the legal system without in-court representation. And while it can seem overwhelming at first, it is absolutely possible to do it successfully if you understand the process and know what to expect. So, if you have a hearing coming up, listen up, because I'm going to break things down in a way that makes you feel more confident about representing yourself. We'll talk about your rights, what you can expect in the courtroom, and most importantly, how to tell your story effectively, even if you don't have a lawyer by your side. Let's start with a term that you might have heard, pro se. When you don't have a lawyer, you're representing yourself, and the legal term for this is pro se. It's a Latin phrase that means for oneself. Now, just because you're going it alone, it doesn't mean you're powerless. You have the right to be there, to speak, and to present your case. You deserve to be heard, and the court is there to listen. Many people successfully represent themselves, especially when they're prepared and know what to expect. One thing you might hear about when you're preparing to go to court is an evidentiary hearing. What does that mean? Simply put, an evidentiary hearing is when the court hears and evaluates the evidence you're presenting. This could be in a family law case when you're showing proof of something like child custody or support. It's your opportunity to show the judge why your side of the story is the one that should be believed. At an evidentiary hearing, the judge will listen to both sides and decide what facts are most important to your case. You'll be able to present your evidence, call witnesses, and explain your position. But it's important to remember that not every hearing is an evidentiary hearing. Many hearings that you will attend over the course of the case could be status conferences. Status conferences have names like a status hearing, case management conference, and pretrial conference. These types of hearings are usually short. The judge will not want to hear you present your case at a status conference and may become frustrated if you try to present evidence at one of these hearings. Evidentiary hearings, such as a hearing on a motion that's been filed, a final hearing, or a trial, are the opportunities to present and defend your case. Now that we've touched on hearings, let's talk about evidence. Evidence is anything that helps you prove your side of the case. Evidence can come in many forms: documents, photos, witness testimony, even physical items. It's important to remember that evidence must be relevant to the case at hand and must be presented in a way that's acceptable to the court. Testimonial evidence. This is when a witness, including you, takes the stand and tells the court what they know about the case. Documentary evidence. This includes things like written documents, contracts, text messages, or emails that are relevant to the case. Physical evidence. Any objects or items that are part of the case. For example, a piece of clothing, a broken object, or something else that might help resolve a conflict in the case. Each type of evidence can help paint a clearer picture of the situation, but it's essential that you understand what types of evidence are most helpful to your case, and be prepared to explain why they matter. This takes thinking, and asking yourself, what does this piece of evidence help prove? So what types of evidence should you focus on most? That really depends on your case, but here are some of the most common and effective. Photographs. Pictures can be a powerful way to show physical evidence, like injuries, property damage, or things related to a custody case. For example, photographs of a home environment. Make sure the photos are clear and relevant to the case. In order for photographs to be admissible, you may need to testify that the photographs fairly and accurately depict whatever it is you're trying to show the judge. For instance, this picture fairly and accurately depicts the injuries I sustained. Text messages or emails. These can serve as written proof of what was said or agreed upon. They're incredibly useful in cases involving communication between parties. If you want to show the judge pictures, emails, or text messages, be sure to print them out and organize them chronologically to make it easier for the court to follow. You cannot just show the judge what is on your phone. If you do not print out evidence, it is possible that you will have to admit your phone into evidence along with anything else that may be on your phone. That will also mean that you will likely not get your phone back. You do not want to be in court having to make a decision of whether to admit your phone into evidence or not show the judge important pieces of evidence such as photographs. So be sure to get relevant evidence printed. And that concludes our discussion on handling evidence for people representing themselves. Remember, even without an attorney, you have a right to be heard. You have a right to present your case, and most importantly, you have a right to advocate for yourself. It may feel overwhelming at first, but with preparation and confidence, you can do this. Be organized, be clear, stay calm. The court is there to listen to your side, and by following the steps we've talked about today, you're setting yourself up for success. You've got this. Now we're going to move on to a story about how community legal services recently helped somebody. I want to tell you a story about Susan. Susan has been a homeowner since 2018. She owned a manufactured home in Volusia County. As is the case with many owners of manufactured homes, she owns her physical home, but she does not own the real property that the home rests upon. Late last year, she allowed her daughter and her daughter's boyfriend to move into her home. Unfortunately, Susan discovered that her daughter and the boyfriend were engaging in activities she knew could threaten her ability to remain in her property, and she really had no place else to go. In an attempt to preserve her housing, she moved to evict her daughter and the boyfriend. But when the two of them were arrested, the neighborhood where Susan lives issued something called a notice to vacate, ordering that she leave the property. This notice ordered Susan to get out in 7 days, even though she had taken steps to remove her daughter and the boyfriend. She now faced the dilemma. Does she move out, try to find a buyer within a week to recover whatever funds she could, or does she risk an eviction being filed with the court, forever staining her record when seeking future housing? Susan was connected to the helpline at Community Legal Services and later our housing unit. One of our attorneys spoke with Susan and advised her of her rights and discussed how she may be able to avoid eviction. Unfortunately, an eviction did get filed, but then CLS housing attorney Gage and paralegal Angela got to work, requesting reports from law enforcement and reaching out to the attorney for the housing provider. Eventually, they were able to advise Susan how to advocate for herself and obtain a forbearance agreement with the housing provider that would allow Susan to stay in her home. According to Susan, if it wasn't for Angela and Gage, I would have lost my home. She said CLS is a wonderful program, and she has since referred others to CLS. Here's another quote from Susan. This program really goes above and beyond to help people out that can't afford the traditional route with attorneys. Angela is professional and kind and generous, and I just can't say enough of good things about her. Gage, the attorney that helped me out, he is also just so kind and understanding to my problem and went above and beyond. I hope this program lasts for a long time because as far as I know, the community needs it and they need more people like this. So CLS would like to thank Susan for the kind words, and thanks Sabrina with the helpline, and Gage and Angela with the housing unit for their commitment to helping empower people in the community like Susan. That wraps up the first episode of Litigation Corner. If you have a topic that you'd like me to cover in future episodes, please write it in the comments. And remember that when you need help or a friend needs help, Community Legal Services is there for the community. See you next time at the Litigation Corner.